Hi, good evening, everyone, and welcome to another edition of our Justice and Peace's guest speaker series. Today's guest is a licensed paralegal with her own practice, Stonegate Legal Services. So thank you so much, Bita, for joining us here today. And perhaps maybe you can start by telling us a little bit more about yourself, how you got into your practice, and then we can start from there.
Well, thank you so much, John, for having me. It's a pleasure to be here and talk to you this evening. I will tell you a little bit about myself. I come from a real estate background. So I obtained my real estate license back in 2004, 2005. I'll try not to age myself too much. And when I received my real estate license, throughout that path, I started working for a small brokerage. And when you're working for a smaller company, you tend to take on things more because they have the time to train you and take you on. And from that path, I started acquiring landlord and investor clients who wanted to purchase small to medium sized apartment buildings, commercial plazas, but they didn't really want to deal with the day-to-day operations. Or some of them were out of province or out of country, and they weren't really here to take on the day-to-day activities. So, like every other realtor, what I did to keep the relationship going with my clients is I volunteered to manage these properties. So, alongside my husband, Rob, what we did is we started a property management company to act as a blanket to manage these properties and take care of certain concerns that tenants had, basically, so that our landlords can be hands off. And then what I found was that I was often going to the landlord and tenant board on matters such as, for non-payment of rent, maintenance of repairs, persistent late payment of rent. And then 9 out of 10 matters would get dismissed because I was not a licensed paralegal or lawyer. So, because I love learning so much, I went back to school. I obtained my paralegal license, again, to act as a blanket so that I can better service my clients. And then I realized that our business just shifted. And many, not only realtors, but their brokers, their managers, and company owners would, approach me and ask me to hold training seminars for their realtors and educate them. Because although you're licensed to trade in real estate, and by trade I mean to participate in a sale or a lease, you're not really trained on the Residential Tenancies Act, the leasing process, and how to put together a proper lease. So unfortunately, I don't practice real estate anymore, but because of our background in real estate, our firm provides support to realtors, to brokerages, and to landlords and investors. So that's background about me.
So, in terms of obviously having that background, when you did made the decision and want to now become a licensed paralegal, I mean, was that sort of the goal there is, look, I have all these clients, and first of all, I went and I serviced them with respect to property management. Now I need to deal with the legal stuff. So again, to kind of keep them in the loop there. And how was that experience like going back to school again a few years ago there to get your paralegal license and in terms of now building your own um, extension of what you've been doing? I mean, how has that worked out for you?
Well, it's worked out great. I love learning. So first of all, I love school. I love to learn, and I love to educate myself because when I speak to someone, I want to make sure that what I'm talking about, I know what I'm talking about pretty much. And because of my background, I already had the experience. So I was already dealing with the tenants. I was already involved in the purchase or in the lease of the properties, acquiring the properties. I was also involved in, resolving the matter between the landlord or tenant or resolving the dispute. All I needed was that piece of paper so that my matters would not get dismissed. So again, because I love learning so much, I went back to school and I obtained my license, which is great. I love what we do right now. It's fantastic. We're better able to assist landlords and investors in educating them that property ownership should be treated like a business. More often than not, we have these clients who purchase the residential home or the condominium, and they feel that this is going to be my secondary source of income. And we educate them. And I'm really hard on my landlords. 99% of my business is landlord based. And I'm really hard on them because some of them come to me and they want to do some things that, the law doesn't support them in it, but they feel that because they're landlords, that they have that power to do so. And it's my job to make them realize that, you don't have the power that you think that you have, that the real estate game or the rental property business needs to be treated like a business. It's the most highly regulated business in all of Ontario. Like there's no other business that has, that a consumer can stay in a property for up to a year, maybe more, incur thousands of dollars and walk away with a slap on the wrist. So, I mean, think about it. You walk into a convenience store, you take you package of gum, you put it in your pocket and you walk out. What happens? You get slapped with, theft. But, a tenant can stay in your property, not pay the rent, complain of every single minor issue. And then you get to the board and the board will consider reasons or, under a certain section of the law, reasons that can be raised to support why they haven't paid the rent. So, I mean, we really want to educate our clients out there because we find that a lot of people entering this business, they don't treat it like a business. They treat it as, I'm landlord. It's what I say goes. And if I say that you have to leave, you have to leave. And that's not the case. And that's what we need to bring to people's attention and educate them on.
Now, in terms of your practice, certainly you have that background there coming from owners and landlords. Do you have clients on both sides, or are you strictly representing landlords for most of your practice?
So most of our practice, I would say 99.9% of our practice is landlord based, but I would be lying if I said we represented no tenants. We do have some really good tenants that we do represent.
Now, I guess then we can sort of maybe focus a little then obviously on the landlord side there, because a lot of people have this perception that when you're dealing with landlords, you're dealing with these big organizations or corporations that have or they have property management companies as well. With respect to not understanding why getting like the situation you just pointed out there was 3 months, 6 months, a year of unpaid rent is crippling. I mean, while it's crippling certainly to the tenants if they're going through financial situations, I mean, it's just as crippling for the landlord. So how do you navigate that when people don't realize, hey, if you're letting them wait before they make payments and you're not chasing after them or you're not filing the relevant applications, that you're the one that's going to be out of pocket?
Well, I always make sure that I tell them that whenever you own rental properties, you have to treat it like a business. And that means rent is late the day after it's due. If it's not paid, it's late. And as a business owner, you have to do what you have to do to protect your investment. And that means you need to serve the appropriate notice. The problem, John Paul, is that because these landlords often don't want to pay the money for a legal representative to do it, they end up filling these notices. They end up filing it with the board. And because of all the backlog and the delay in the landlord and tenant board, we're looking at about a 7 to 9 month wait just to get a notice of hearing to go to a hearing. Right. And that means if a tenant hasn't paid, then if it takes 9 months to get to a hearing, that's 9 months of arrears that has accumulated. And only to find out that when they get to the board that there's an error because they didn't spend the money, they didn't want a legal rep to do it, they did it themselves. And at the board, there's an error and their application gets dismissed and they have to start all over again. And it's actually because of the board. And I blame the board for this because the board needs to tighten up the way they are running, because these delays are causing extensive hardship to a lot of landlords. I just had a hearing today and the tenant hasn't paid for 2 years. 2 years. This particular landlord, prior to retaining me, they had filed 4 applications on their own for non-payment of rent. So 2 years, 4 applications. I mean, months of waiting to get in front of the board, $36,000 in arrears. and the tenant wanted to wait until the end of the month to move. We luckily got the eviction order, but again, these extensive delays is what, causing a huge prejudice to the landlord, because some landlords are losing their shirts because of these, as a result of these delays.
Now, I mean, it's not as simple then as saying, like, it's not like the landlords can come in and change your locks overnight or just remove you. So, what options? I mean, when someone comes and says, look, Bita, they haven't paid in 2 months. I can't afford this. I mean, I'm also hit with impact of COVID, for example, on my other businesses. What can you do to speed up the process, or at least reach some kind of agreement of how to catch up on the late or missed payments?
Okay, so I can only speak for us, our firm. So I'll tell you what we do. I can't speak for other legal reps because I really don't know what they do. What we do is we take the more proactive approach. So we actually pick up the phone and we call the tenant to see, what is your position? You have incurred X amount of money in arrears. Based on the amount of money that they've incurred, either we put together a repayment plan, giving them the opportunity to pay. At the same time, we commence a legal proceeding, so that even if they do agree to a repayment plan, when we get to the board, we can show the board that, Mr. and Mrs. Adjudicator, we have taken the following steps to, have the tenant commit to a repayment plan. Whether or not the tenant agrees, that's not in our control. We have to do what we have to do to protect our clients. So we want to make sure that we take the appropriate steps. Now, repayment plan is great because I always explain to my landlords, it's a win-win situation for you, even if you want the tenant evicted, because if they pay, they can stay. Great. You get paid, you win. If they don't pay, we can proceed to evict them. You win. So the landlord can't really lose in this situation, but we have to take the appropriate steps to show the board, that we've contacted the tenant and we are making attempts. This is what we do. We take the more proactive approach. I mean, anyone can either file an application with the board and wait 6 or 7 months. You can do that. I can do that. Joe Blow can do that off the street. What you have to make sure when you're hiring someone to work on your behalf is that they are more proactive.
I see a question here that's related to that. Does the tenant just continue living in the home without paying, or are they required to continue paying monthly rental fees, or does no, I mean, until the order is eventually issued? But does that, come up that, hey, they just stop paying for this entire period of time when you're looking at getting an eviction, or could they just come to the board? Here, by the way, here's our $10,000 or $36,000 in back rent. Sorry about that. All the best, and I'll see you back here in a year or so.
So let me tell you. So to start off, to answer your question, a tenant has 4 chances to preserve their tenancy. Okay, 4. They have 4 opportunities to preserve their tenancy. So number 1, if rent is not paid on the day that it's due, on the day after, the landlord can issue a non-payment of rent notice. So the first opportunity that the tenant has to void that notice, they can do so within the 14-day voidable period indicated in that notice. The second opportunity the tenant has is to pay in full before the hearing date. The third opportunity the tenant has is to pay in full on the day of the hearing. And the fourth opportunity that the tenant has is to pay in full before the sheriff arrives to physically evict them. So if and I say 4 opportunities, you're probably thinking either, wow, that's a lot, or wow, that's not enough. But if you consider spreading the 4 opportunities over a timeline, you're looking at about maybe up to a year the tenant has 4 chances to preserve their tenancy. So they have a long time to either move out, pay, or dispute it at the board because they think that they're entitled to a portion of it for whatever reason.
Now, what happens? Let's say they go through all those 4 opportunities. They don't pay. The sheriff comes, or they leave, or however they vacate the premises. What are you doing for that 2 years of $36,000 now?
So when we have the order, so we go to the board, we get the order, we evict the tenant. That's the number 1 thing we do, we evict them. Once you have an order to collect the arrears, the landlord can now enforce by garnishing their wages or their bank accounts. Now, provided that the tenant is working, because if you have a tenant that's on social assistance, if they're on pension, if they're off of child tax benefits, whatever benefits they have, we can't touch that. We can only touch income, like working income, if they're employed. And by law, the provincial law is that we can only garnish 20% per paycheck until all of the arrears are paid. So, for example, for my landlord today, who the tenant owes 36,000, it's going to take her years to pay that money back. But that is money that the landlord is entitled to. So I definitely push my clients to pursue garnishment. Definitely.
And now, kind of sort of related to that, then as well, is if if you can create independently, I guess, an ability there to take some kind of payment plan, right? I mean, preferable than waiting 2 years. I mean, or work out some kind of agreement. I mean, that's what the proactive approach you were talking about, right? Is that, look, rather than just say, let's go to the landlord tenant board and we'll see how it goes, and then we may have to go to small claims court afterwards. And you're looking at, I mean, if this client looks like it's going to be 3-4 years before they see any of that money. But have you had success in just saying, look, let's try to keep this out of the board, out of the courts, and work with the tenant to kind of come up with something? Maybe we don't get the full amount of money, but at least we get enough of it to justify that, you're not going to end up waiting 4 years to maybe get, I mean, and then they're going to be 20% of $36,000 or whatever they make. I mean, that's still going to take another couple more years. So we're looking at maybe 6 years for this unfortunate landlord here before they may be fully, or if ever, fully compensated.
Well, this is one thing all landlords need to know, is that don't get into this industry if you think you're never going to come across a bad tenant. It's inevitable, because tenants have they have the internet at their fingertips. They have access to the landlord and tenant board. They have access to free duty counsel, free legal aid. These are things that it's going to help them become more knowledgeable about their rights. So one thing that we always do, not only being proactive, is that if landlords want to get rid of that tenant, but they want to wait to go to the board, we have what I call a cash for keys. And I'm going to tell you a little bit about that if you haven't heard about that. And what we do is we use the arrears as a strategy in order to get the tenant out. Does that make sense? Because, and I tell my clients, because some tenants, good luck getting that money back. What you want to make sure is that tenant leaves in the next 30 days. This is the strategy, because the more you take a stand and the more you dig your heels in and say, no, I want to go and evict them, that's going to take 9 months. Within that period, how many thousands of dollars are you going to lose? So we have a very effective strategy, and I call it cash for keys. And a cash for keys is exactly what I call it. What we do is that we draft a proposal giving the tenant a couple of options. For example, option number 1 is that you leave at the end of June. So you leave in 30 days, and the landlord will agree to forgive your rent arrears in the amount of whatever, 5,000, 10,000, whatever. We've had great success with tenants committing to that. What is the alternative? The alternative is do nothing, wait till you get to the board, which could be months down the line. And how many more thousands of dollars are you gonna incur? So we've had a lot of good success with the cash for keys, depending on the type of strategy. So sometimes the landlord will agree to a rent forgiveness. Sometimes the landlord will agree to paying the tenant to leave, offering them cash in exchange for the keys and termination of tenancy. It really depends how we can use that strategy to end the tenancy.
And I think certainly it's kind of like, I think in accounting, I mean, I wasn't the best accounting student when I took it, but I believe it's a sunk cost, right? That at some point you just say, well, I've lost this money. And I think, I mean, even it's like, I think the analogy of gambling, right? It's like, oh, I want to get back to what I started with today. So let me just keep playing, right? I mean, the landlords, they're digging themselves into a further and further hole, just trying to get as much back as they may have lost. But I mean, you're also continuing to lose. And I think sometimes, even in other areas of law, right, when you have clients that are plaintiffs, that they're wanting to get everything, it's sometimes a matter of principle. And how do you kind of deal with those clients, whether it's in the small claims court now or if it's still at the landlord tenant board, where they're like, well, why am I losing $5,000 or $10,000 because they had agreed to pay $2,000 a month and they stopped paying now for 4 months? So why am I giving up on this eight that I didn't do anything wrong?
Yeah, and sometimes that is what we hear. It's a matter of principle, or I'd rather pay you than pay the tenant to leave. And after they calm down, I let them know that a matter of principle is going to cost you $10,000. Or you can tuck your tail in, pay them the $5,000 or whatever, forgiveness, whatever the strategy is that we're deciding, and move on. Get this person out as quick as you can, because digging your heels in as a matter of principle is going to cost you more money, which you can take and do whatever you want. You're complaining about how the tenant is not paying, and now you're saying, as a matter of principle, I'm going to lose more money in order to prove the tenant wrong. Well, you're shooting yourself in the foot. So sometimes they come to reality. Sometimes it takes some landlords a little longer, but we do find that they do come around because, this is the truth. You're dealing with people's lives, and you're dealing with a business. Like, it's highly regulated. And that's why I say to these landlords, if you're not prepared to deal with a tenant that is going to give you a hard time, don't get into this business. Don't get it, because it's inevitable. And I'm talking because I'm a landlord myself. So I practice what I preach. And I've been lucky, and I haven't come across a tenant that I've had to use a cash for keys strategy for. But if I did, I hope I don't become hard-headed and say it's a matter of principle. And that's where my husband usually calms me down and say, let's just get this tenant out. We have to practice what we preach, get this tenant out. And that's what we tell our clients.
No, that's great. And certainly when we're looking at real proactive advice, and maybe this is something you may be dealing with, certainly as a landlord, perhaps it comes up directly there, is doing those background checks. I know it's not always possible, but I know some landlords don't do anything. And then 3 months later, they run into trouble. And like, well, what did you expect if you didn't do a credit check on the person? So what do you tell if people come to you and they want, and certainly I know you do that on the other aspects of your business there, when they come and say, hey, I'm looking to dip my toe now. I see obviously housing prices are going up and up, and I need somewhere to pay off a mortgage and things like that. What do you tell new landlords about kind of the Residential Tenancies Act and everything that goes with it?
Well, what I tell new and veteran landlords. So let me tell you, the vetting process, you can save a lot of aggravation if you vet the tenants properly from day one. And by vetting the tenants properly, I'm talking about credit checks. I'm talking about Google. It's amazing what you'll find out about a tenant when you Google their name. Social media. People love their pets, right? People have thousands of pictures of their pets, so sometimes more than they have pictures of their kids. So if you receive that rental application and you ask, do you have a pet? And that tenant says no, and their social media pictures shows their picture with, Garfield, that they have a pet, right? So you can find out a whole lot about people on their social media. So vetting is very, very important. What I tell new landlords is that they need to become familiar with the Residential Tenancies Act. They need to become familiar with the law. If a tenant stops paying, what if I want to move into the property? What if I want to sell the property? How do I terminate tenancy? Can a landlord even terminate tenancy? What are the ways of terminating tenancy? These are things that new landlords need to become armed with, because remember, tenants have information at their fingertips, but because the way the landlord and tenant board views a landlord as Mr. Deep Pockets or Mr. Moneybags, you have the funds to hire a legal rep. But this vulnerable tenant who is using your property for housing, needs assistance and needs accommodation. You need to be accommodating. You need to make sure you know what the law is, or team up with someone who knows what the law is. Definitely.
Certainly better to not have those issues than have to be reactive to them when they come up. I see a question that's kind of related to what we're talking about in terms of purchasing, but what if now you want to buy a house or you've bought a house and it has pre-existing tenants and they've been paying on time. There's no issue with them, but maybe you want the house or you want to bring in new tenants. Certainly the price can go up with new tenants, obviously, compared to the pre-existing ones. Can you do anything as the new homeowner, or are you stuck with the tenants as they come with you?
So we do a lot of training for realtors, okay? And we train these realtors because 99.9% of realtors do not read the agreement of purchase and sale when they're putting a contract together, okay? It's just the nature of the game. So when we train them, we tell them that when you're purchasing a property that's tenanted on behalf of your client, there is no guarantee to vacant possession. There is no such thing as a guarantee to vacant possession because all parties involved in the transaction are relying on that tenant in order for them to make a move so that the deal can close. And if that tenant, for whatever reason, if they lost their job, if they're sick, if they're not working, COVID, if they can't move, your deal's not going to close. But if, as a realtor, you include a vacant possession clause, or if you guarantee a vacancy on closing, you're putting your client in between a rock and a hard place because your seller has to jump through hoops and they have to serve the proper legal notice. In that proper legal notice, which is the N12 for the landlord or purchaser's own use, on the second page, because I tell them like the exact way I'm telling you, is that, turn to the second page, the third bolded box from the left down, it tells the tenant, what if you disagree with this notice? If you disagree with this notice, you don't have to move out. So it's right in there. So although the seller landlord is serving a notice to terminate tenancy to the tenant, that notice tells the tenant that you can contest this by not doing anything. And therefore, the seller landlord now has to apply to the board, wait 7 to 9 months for a hearing date, and then wait for the board or convince the board that they have sold their property, in fact, and the new purchaser has to now convince the board that they require vacant possession for their own use. So in order to sell a property, I always go back to the realtors because these are the professionals that the public is going to help with the sale and purchase of the property. So they have to know that there is no guarantee to vacant possession.
How do you sort of deal with, there's so many moving parties there, right? In terms of, you have the seller, you have the purchaser, you have the tenant, you may have a new tenant that they may be wanting to bring in down the road, right? And everyone's kind of relying on this transaction to go, or the series of transactions to go smoothly. What can be done there if you are, let's say, the sellers of the house there to ensure that you can try to get vacant possession over to the purchasers?
Cash for keys. Cash for keys is amazing. This strategy has worked very effectively. And I'll tell you why. Cash for keys, I always recommend that when my realtors call me and they say, what do we need to do? I say, cash for keys. Cash for keys, let's get them out. And then that way the seller can do whatever they want. They won't restrict showings. The tenant won't restrict showings. The tenant won't refuse showings. You can show the property anytime you want on any day. And you can guarantee vacant possession because the property is vacant, right? Cash for keys is very effective. So I highly recommend for a tenanted property, the cash for keys are done. You can get rid of the tenant and then you can do whatever you want. You can sell the property, re-rent it at a higher amount. You can move in, your mom or dad or your brother or sister, whoever you want can move in. You're not restricted. Whereas if you sell the property and the new purchaser requires vacant possession for their own use, they actually have to move in for at least 1 year. So they cannot re-rent that property for another year. They cannot resell that property for another year. There are requirements and consequences that come with these notices. Cash for keys, we make the rules.
That's cool. It's certainly a way that there's mutual benefit, right? Is that they're getting a discount or a number of months for free, and the seller is getting that peace of mind that they're not going to be there on such and such date so that they can close on the sale to the seller, to the buyer.
You got it.
And Now, with that, with those forms, what other requirements? I know you touched on this. So, what are some of the requirements that the now landlord have to provide to the tenants in order to, I mean, let's say outside of a cash for keys arrangement, in terms of the N12, what do they need to provide the tenant? How much notice and any financial compensation for leaving as a result of a sale?
Okay, so the N12 has certain requirements. One of the requirements is per section 49 of the Act, compensation. Compensation has to be paid in the amount of 1 month's rent on or before the termination date, whether or not the tenant leaves. Okay, it has to be paid. This is a requirement that has to be fulfilled. Otherwise, at the board, the matter will be dismissed. Right? The termination date must be the last day of the rental period. I know that some leases, when they're drafted up, they go from the first of the month, 1st of September 2020 to the 1st of September 2021. Well, that's incorrect because a contract cannot run from the first to the first. It can run from the first to the 30th or the first from the 31st, but not from the first to the first. So the date of the termination has to be the last day of the rental period. Another requirement of the N12 is that it is free from any and all minor errors. Okay, that means that if you forget the rental unit, if you forget to put basement apartment, if you forget to put the postal code, these automatically invalidate a notice. Okay, and you're risking the notice and being dismissed on the day of the hearing. So this is basically the N12. We have to fulfill certain requirements or consequences. Otherwise, the matter will get dismissed and the process has to be restarted.
In terms of that process there, in terms of what are some of the things that, so you highlighted the compensation there and the periods there, but what are some things that landlords should be aware of when they're going to navigate a situation like that? I mean, certainly we've talked a bit about cash for keys there, but what else to kind of be prepared for? I mean, in terms of showings, right? Like what you were mentioning, the tenant can restrict some things there in terms of all of that. What have you seen in terms of, especially now in the COVID times, what happens when this whole process is going on, and what advice do you have for landlords out there who are trying to navigate it?
So this is where it comes a little gray. It's not black or white. There's a gray area with respect to showings. And I'll tell you, we have some clients who the tenant is not allowing for showings. I'm not letting anybody in. I'm not letting the landlord in. I'm not letting the realtor in. Nobody's coming in because of COVID. And then we have other tenants who say, we'll let a certain number of people in on Monday between 10 and 12, or on Tuesday between 4 and 6. The showings are very restrictive. We're finding that there are some tenants that are restricting the showing times. This is the beauty, again, of cash for keys, because once a tenant is gone, you can show the property at any time. But the challenge that a lot of landlords are facing right now in listing and selling their property is access to the property.
And again, on the other end there, now what happens if, I know there's some tenants here who would be listening, that someone says, hey, I'm going to sell the place, or I'm going to move in myself, or, my kids are coming back because there's no school to be going into in person now. And then you find out months later after you've left that, hey, that wasn't the case. They were just fooling me, pulling the wool over my eyes. And turns out that it was just a cooked story so that I can get out of there. And now they're renting it for way more than what I was paying.
So that is a terrible spot to be in. Okay. And often when I have calls, my prospects call me and they say, well, we want to move in. And I ask them, do you really want to move in? Because you have to tell me the truth. I can't just send a notice saying that you want to move in, and then a month down the line, you get slapped with a bad faith application, because that's exactly what's going to happen. And then I find that some landlords actually say, no, we really want to move in, or no, I just want to get the tenant out so I can sell it. So for those landlords who are truthful, thank you. For those landlords who are not truthful, what we need to do is we need to basically clean it up. So we need to make it truthful, because I'll tell you, the consequences in serving a notice and not following through, especially if the tenant relies on that notice in order to make a move, the consequences can cost you up to $50,000. Okay, and that is if a tenant brings a bad faith application against the former landlord for the same reason that you just said, is that the landlord sold the property or re-rented at a higher amount, but they gave notice that they wanted to move in. Okay, and the tenants have, again, they have 12 months from the date that they move out to bring forward a bad faith application. Okay, so the way the board looks at it is that, there's a three-part test. Let's talk about that. And there's three questions that the board asks. The first question is, did the tenant rely on that N12 in order to make a move? The second question is there an advertisement of the rental unit or the rental property? And the third question is, did the person who was supposed to move in actually move in? Okay, this is the test to bad faith. And if you fail that test, no matter what excuse you use, right? Because sometimes the excuses that we find are, my life took an unexpected turn, or things changed, or I got accepted to another university in another country. Well, these excuses doesn't change the fact that the tenant relied on your notice in order to move. More than likely, they packed up their children, their spouse, their furniture during COVID to find another rental unit at a higher amount of rent per month than what they were paying you, and then only to find out that 1 or 2 months down the line, you sold the property or you re-rented it for $1,000 more a month. What would you do if you were in that situation? I know I would be really upset. So I'd want to slap that landlord with as much money as I can. So when I come across these scenarios and I explain it to the landlord of what could happen, and then I say, hey, Mr. Landlord, what would you do? And then they usually come down to earth and they say, well, yeah, you know what? You're right. If I was in their position, I would bring forward a bad faith application. So, and if they don't have any other choice to terminate tenancy, cash for keys is what we go back at. Because cash for keys will cost them less money, right? And then they can do whatever they want with the property. They're not limited.
So if, let's say, there's a situation where you don't, like, the landlord doesn't necessarily know about this whole process, or the tenant, and they kind of basically say, oh, you got to leave, and there's no N12s or nothing filed, and they do end up leaving. I mean, are they kind of now captured under this sort of cash for keys agreement that's separate from it, or are they, like, if there was no notice ever given, I mean, are they still subject to them saying, hey, this was in bad faith, they told me they were their kids were coming in and now they're not coming in, and but there's no N12 to really speak of? What happens in a situation like that?
So the beauty of cash for keys, again, I'm only talking for our firm. We don't just get an agreement signed to end the tenancy. When we're doing cash for keys, we do a proposal. And in that proposal, we have terms of settlement. And in these terms of settlement, it's disclosed that all parties moving forward are agreeing to release one another from future liability. So the reason why we are agreeing to end the tenancy in exchange for compensation is that the parties will no longer come after one another on any legal action against one another. Whether the landlord wants to move in, whether they move their brother and sister in, or whether they sell the property. That's the whole purpose of the cash for keys, is that the landlord can do whatever they want. Right? So if the tenant tries to dispute the cash for keys, that's where the terms of settlement comes in. Right? The terms of settlement states, this is what everybody agreed to. This was the understanding. This was what the tenancy was terminated on. These were, the clauses, the conditions, they were all fulfilled. The tenant, received compensation, and everybody moves on. That's the whole point of the cash for keys. And, I have to say, some landlords, when I bring this, option to their attention, some of the landlords that are experiencing difficulty with their tenants, they seem to take the stand that, or feel that, cash for keys is extortion. Why do I have to pay a tenant $10,000 to leave my property? Right? And we tell them it's either you pay the tenant to leave the property so that you can achieve your end goal. Remember, focus on the outcome, not the obstacle, right? The tenant is just in the way. We need to get the tenant out of the way in order for you to achieve what you want to achieve. Or you can do what you need to do, serve them with the notice of the N12, or proceed to try and sell the property, try and get the tenant to cooperate. Hopefully they cooperate. And even if they cooperate, what's happening right now is that some tenants will cooperate and then they know that a cash for keys exists. So what they do is they wait for the N12. And because the N12 says that, hey, Mr. Tenant, if you don't want to leave, you don't have to, the tenant will take the stand that I'll wait here another 9 months unless you make me money, you make me an offer so I can leave. Right. And then the seller is actually now put in between a rock and a hard place, because now you have an agreement of purchase and sale that you guaranteed vacant possession. So now you have to pay the buyers to stick around. You have to pay a penalty for breach of contract, or you pay a fraction of that penalty, get the tenant out, and close on your deal. Right.
Right. I mean, it's just simple mathematics sometimes, right? But that's when you got to separate the emotions from the problem there. And I think so, separate the people from the problem, right? And you just look at it in a financial situation, and maybe that's how you break through there to some of those clients that are insisting that it's somewhat of extortion there, that you have to explain the financial ramifications.
Absolutely. And it's not easy. Sometimes it's really not easy, but it is what it is. And one wrong decision or one act on emotion can cost the landlord thousands of dollars out of pocket.
Now, I see a few questions here. I mean, I think I want to make sure I get through all of them here about, so if someone owes you the 1 month there under the N12, but they owe you months of rent, you just kind of do a set off, right? That, you owe us 4 months rent, we owe you 1 month, you pay us 3 months. And that would satisfy that. I mean, obviously we can go beyond that with the cash for keys there, but let's say under the minimums there from the N12, does that satisfy by just forgiving them the 1 month of rent?
That depends on what you agree. Remember, every matter is different. Sometimes what tenants want is a full forgiveness. Sometimes they want a forgiveness and $5,000. The beauty of a cash for keys is we call the shots, right? You're negotiating. It's hard to negotiate with yourself, pretty much. It is what it is. And if the landlord has to forgive a certain amount of money in order to get a 30-day termination, well, this is what happens when you get into the real estate game, right? You have to sometimes suck it up and pay off that tenant in order for the tenant to leave, to end that nightmare.
I guess that they were looking in terms of maybe just the N12 route, but I think, as you point out, that, well, hey, you can do that as a setup, but you're waiting 9 months for that. You might as well pay a little bit more now, or whatever more now, and get them out now, rather than let that 4 month debt accumulate to 13 right. more months.
And it's not guaranteed that even after the 9 months, the landlord is going to collect. If that tenant is on assistance, good luck collecting. So now that you're taking a stand and you're saying, well, it's a matter of principle, how are you going to collect from someone who doesn't have income, like someone who doesn't have employment to collect from? You can't get blood from a stone, right?
Right, exactly, right? So it's not just, well, you're putting yourself in a position a year from now that you may be able to collect some more money. So again, when you do the risk reward analysis there, maybe that's where you can explain, well, hey, you're going to pay this much now, but you'll have them out. And if you don't pay this much now, you may have them out, or it may be a while before you have them out. And then you may get some of that money, if not none of it. So
right.
If they're still willing to go through all that, then, I mean, you've got your instructions there, but at least, you probably want to confirm that in writing, that you advise them of considering some of these other options. But ultimately, especially with the wait times, so maybe we could talk a little bit more about the wait times and how the board's running now. I mean, with COVID, right? I mean, everything going virtually. Is it on Microsoft Teams, I believe, or how are they being conducted at the board? I know you had a hearing earlier today.
It is. So it's on it. They're working effectively, I have to say. They are using Microsoft Teams and Zoom as a platform. Today, it was my first hearing where there was 45 parties. I mean, when your hearings become larger and larger, it becomes really difficult to control 45 people on Zoom. So there were 2 moderators or 2 mediators and 2 adjudicators. And it's really interesting. They have these blockout rooms where they can put you in different rooms so you can talk to the tenant all on Zoom. And I'm a huge fan of this because now we're able to service all of Ontario because everything is virtual. Right. So, I mean, it's moving along. The hearings are moving along. We're finding that when we file, there is still a delay. There's going to be a delay because when the board shut down on March 16, 2020, they stopped hearing applications with respect to evictions. And that's landlord applications. And then on August 1st, 2020, they started holding online hearings. So from March to August, they started accumulating applications. And I would say, I think something was somewhere around 80,000 applications were received by the board between that time. And 90% of those applications were landlord applications. So that explains all the backlog. And that's why they're trying to, I guess, work as effectively and efficiently as they can, which they are doing. But again, it's going to take time to work through this.
Now, I see another question about strategies, and obviously every case is different in terms of coming to a cash for keys negotiation. How would you advise clients to kind of approach that? I mean, because at the same time, the amount of X there for the cash is going to be critical in terms of both sides agreeing and signing off on that. So is there sort of a negotiation strategy that you kind of help your clients with, or again, is it so much difference from client to client that you just kind of come in there like you do when you go to like the car dealership or something and you try to negotiate, or at the flea market, right? I mean, is there a method to the madness?
Well, what we want to do is we want to let the landlord know that your offer needs to be reasonable. It's not a negotiation where we go back and forth 5-6 times with the tenant, because the longer it takes to negotiate a cash for keys, you're opening the tenant up to the possibility of contacting the board, going on Facebook forums and finding out what other people are doing for cash for keys, calling the board, or going online. We want to limit the tenant's time to do research. So that's why your proposal has to be fair and it has to be reasonable. We usually ask the landlord, what is the rent? So if the rent is $1,500, well, then it's safe to say that an enticing offer is anywhere from $5,000 to $7,000. But I also let my landlords know that I've had other landlords who have paid $10,000, $20,000, $50,000, $70,000, $100,000. We just did one not too long ago for $150,000, which the tenant declined. So these proposals are depend on what the rent is, depend on how many arrears are accumulated. I mean, obviously, if a tenant is paying $1,000 a month, you're not going to go and offer them $100,000. If the tenant is paying $13,000 or $14,000 or $15,000 a month, well, you may want to consider $100,000, right? So it's all relative to how much the rent is.
Are you going to have landlords? Some tenants listen to this talk and they're like, "I didn't get $100,000." Bita told me $100,000 I should be holding out for that. But I mean, obviously, it's relative to the amount you're paying and the timing.
It's relative, and you know what? The tenants have to be reasonable too. What I make it clear to the tenant in my proposal is that you're not entitled to anything. This is not for you to capitalize on. If you want to capitalize on something, go and buy a property and you rent it out and then you sell it or do whatever you want and you capitalize on your property. This is not your property. The reason why we're doing a cash for keys is to expedite the wait times of the landlord and tenant board. Because if we were to proceed through the board on an N12, you're only entitled to 1 month's rent. So you can take the $5,000 that we're offering you, or we'll wait it out and we'll get to the board and then we'll go after you for the arrears. We'll hit your credit and you'll only get your 1 month's rent. This is what we made clear. So even though I'm telling you what's been going on and what we've done, I mean, tenants cannot hold out for $100,000. It's unreasonable. It's an unreasonable expectation, right? Unless you're paying $25,000 a month, then knock yourself out. Wait for $200,000. Who knows? But they're not entitled to this amount of money. It's not a way for them to capitalize on the landlord's investment.
Right. And it's essentially, I mean, it doesn't mean, and I think this came up in a question or a comment I saw, it doesn't mean you get to stay rent free until the hearing, right? I mean, it doesn't excuse that obligation, right? Regardless of what's happening, you still have to pay it, whether you pay it now or you pay it at the board on that day, or you pay it at the time the sheriff is coming, or at the small claims court to plus costs and everything like that. But I mean, it's still an obligation. Otherwise, like you said, could affect your credit, and there could be liens placed on future properties or garnishments of wages. So I think that's also something that landlords should know, is that it's not a free ride for the tenant. So you got to explain that to them, that, hey, I'm giving you 3 months of free rent. You're only really entitled to one. Maybe that'll help you take that offer.
Yeah, exactly. Exactly. And again, we make it clear that they're not entitled to anything. This is the proposal. The purpose of the proposal is to expedite a termination.
I see a few other questions here. What happens when there's multiple tenants and one tenant leaves and then the other one doesn't? Like, can you go after both of them? Like, if they're both on the lease, I mean, is the tenant going to essentially say, "Look, hey, I don't know what they were doing. I have no control over them. I gave vacant possession and I left." What do you do in those situations?
So all parties, all tenants, all landlords are jointly and severally liable. So they're all responsible. If one party leaves and there's two tenants, well, both parties are responsible for the rent payment, even if one party leaves. And I'm only telling you from my experience is because that party who leaves and they leave behind the party who maybe can't afford the rent, why are we going to let that party off? That party will be the one we'll use in order to get this one out. And again, this type of law, when we're practicing the Residential Tenancies Act, we're practicing in this type of tribunal, our firm, we do a lot of strategizing. We don't want to just release a party, because sometimes that party is going to help us get rid of the one who's staying. Because if we go after him, we say, hey, John Paul, you're gone, you're working, this Joe Blow isn't. So it's either you convince Joe Blow to leave with you, or we're going to hold you liable. We're going to come after you for the arrears because you're on the lease. Now, if we have an order to evict and you leave and the other party is still in the property, then it's okay, because we're still going to enforce that order and evict, right?
It's kind of hopefully you're getting indirectly at the person that's still there through the person that's left.
Right. It's a lot. There's a lot of strategy that we use in order to terminate tenancy.
Now, another one here about maybe comes under mitigation of loss, right? Is, well, hey, if you already have another tenant ready to come in, I mean, what are you losing on a situation if someone wants to maybe end the agreement earlier? So what happens if someone is trying to kind of double dip there as a landlord? Does it still go to the board if they actually have a replacement in line, or do they have to show that loss that they're suffering as a result of not getting the amount? Like, I mean, if someone's not paying you and you're like, okay, well, we'll wait it out, but meanwhile you have options available and you don't go to the board to file the eviction. I mean, can you use that against the landlord, that they're just being complacent?
You can. I don't know how far that would go, but we definitely let our landlords know that if you're breaking, or if a tenant is breaking a lease, as a landlord, you have to minimize your damages, right? Definitely get that place rented out as soon as possible. You cannot double dip. The board won't allow you to do that. The small claims court has no jurisdiction to decide on landlord and tenant disputes, so they'll dismiss it if you try to go there. You have to minimize. So the only thing you can go after the tenant for, the only period of time, is that if the tenant leaves on, let's say, May 31st and your new tenant moves in on July 1st, you can only go after them for the month of June, because that was when the property sat vacant and you had a lease. That's the only thing. You cannot go after them for anything else. And 90% of the time, it's really not worth it. Get that tenant out. Do a better job, learn from the mistake that you made. What did I do wrong in the vetting process with this tenant that I'm going to avoid doing with the new tenant? It's all a learning process. Try and get a better tenant. There are really good tenants out there. As much as there are good tenants, there are good landlords. But you do come across that bad apple that ruins it for everyone. And that's why the vetting process is really important.
As well, I see one about, we were talking about showings and stuff before. Can a tenant basically say, look, no showings unless they're virtual now? Or can that be that restrictive, or do you have the ability still as a landlord to say, well, we can try to honor some of your suggestions, but we can provide notification and be able to come and show whatever we want? I know that's kind of like a gray area, but what are your thoughts? What have you seen in kind of finding that delicate balance between the two sides?
So in accordance to Section 27 of the Act, the Act says that a landlord can show the property with 24 hours notice with their realtor, or the realtor can come in with 24 hours notice. So I make it clear to the tenant that, Mr. Tenant, you have no say. You are not involved in the transaction. This has nothing to do with you. Your role is just that, is you are the tenant. You cannot interfere with the showing. If you interfere by way of restricting the showing, by way of refusing the showing, the landlord can bring an application to serve you with notice and bring an application to the board to evict you for interfering with their lawful rights of selling the property. So we have to make that very clear to the tenant that they have, although they have certain rights, they do not have the right to interfere with the showings at all.
I mean, that's great there to know that you can't just lock the door and not let anybody in or something like that.
No. Although we do have tenants who do that.
What about in terms of, we were talking about sort of the onus there on the sellers, or intending to move in, or there's someone purchasing it, in the N12 there. What needs to be provided there to satisfy that, in fact, that this is going to happen? Is it just, hey, you take them at their word, and if they turns out that they were lying, then you bring the bad faith application? Or do you need to require, hey, here's a for sale sign on the lawn, and here is proof that we're going through the process? I mean, what if anything needs to be communicated to the tenant outside of the N12 form?
That's why the N12 needs to be served on good faith. So there's a good faith intention behind serving the N12. Again, the tenant is not required to be provided with an agreement of purchase and sale as proof that the property is sold. They're only entitled to that information if they contest the N12 and don't move out. And that's on the day of the hearing at the board. If they take in good faith that application, the N12, the notice N12, and they rely on it in order to make a move, and then they find out that, hey, you didn't sell it, or you rented it, or you didn't move in, then they can come after you. And they have a year to do that. They have 12 months to do that.
What about on in repairs? Say a question here about, we were talking about COVID. Now, what about if you are the landlord and you're looking at it as, hey, I'm not going to do any repairs because COVID, and I don't want to risk either myself or whoever I'm bringing in potential risk to contracting it. And we have all these essential orders and things like that. I mean, can they basically say, look, no maintenance until COVID's out of the clue, or is that not acceptable on the landlord's part?
No, they cannot restrict maintenance. See, COVID is not in the law, right? There is no pandemic in the law. The law doesn't say because of COVID you can't do this, or because someone is ill you can't do that. You have to allow the landlord to maintain the property. You have to allow the landlord to access the property. Now, if you're quarantining, then we ask that you use your common sense and not enter the property during the period of time that the tenant is quarantining. I mean, that's common sense. I wouldn't want to go into a property if the tenant is quarantining, would you? Probably not, right?
I think it's sort of it's the opposite, that the landlord doesn't want to come in to do the repairs, not that the tenant doesn't.
Well, no, the landlord has the obligation to come in. Under Section 20 of the Act, the landlord has to maintain and repair the property. And this includes snow removal, this includes grass cutting, this includes minor maintenance, this includes if the appliances are broken down. The landlord has a duty to maintain and repair. They cannot go around that at all. It doesn't matter if the lease says that the tenant has to cut the grass and mow the lawn or shovel the snow. It doesn't matter what the lease says. The Act says, Section 20 of the Act says that the landlord has the duty to repair and maintain.
Now, in terms of, I mean, maybe this is a good question here to finish off with everything about the lease agreements. I mean, they've gone now standardized. So, what happens if you've signed off on things that are not part of, or you've filled out paperwork that's not that? I think it's an RIA form, like the standard form there of here's the tenancy agreement. Can anything be done? Like, is that still enforceable? I mean, if you said, well, hey, you agreed to cut the grass now, and you're not cutting the grass, what happens?
So any clauses that are inconsistent with the act, the Residential and Tenancies Act, is automatically void and unenforceable. That includes a no pet clause, right? You can't say you can't not have any pets. You cannot discriminate against people who have disabilities. You can't say John Paul is responsible to cut the snow, shovel the snow and cut the lawn. You can't do that. These are certain clauses that are inconsistent and unenforceable. The last thing you want is to go to the landlord and tenant board and say, hey, John Paul said he didn't have a pet and he has a pet. What do you think the adjudicator is going to tell you? That you're discriminating against someone for having a pet, and you can't do that. So any clauses that are inconsistent with the act are deemed void and unenforceable.
So best bet is just to stick to print out the one online there and just.
There you go.
So Vitas, thank you so much here for joining us and sharing on that. A lot of questions, and I think we got through all of them. Just double checking if there's anything left here. But yeah, I think we got through everything. So I was wondering if you have any final words of wisdom for anyone listening, specifically, I guess, my students who are kind of going from this process there now, from being students to hopefully being licensees one day. And I know at least one here who's really interested into getting into landlord tenant because they also have a similar background in real estate at one point. So any words of advice for them? And thanks once again for joining us.
You're most welcome. So my words of advice is get familiar with the act. Definitely get familiar with the act. Don't just fill out forms and wait for the board, right? You're doing your clients an injustice by just waiting around and not being proactive. Definitely be proactive and get familiar with the act. I cannot stress that enough.
So thanks everyone for tuning in. Thanks again, Bita, and we'll hopefully see you tomorrow again at 5:00, everyone, with Gina Alexandris joining us. Take care, everyone.
Bye, everyone.
Thank you so much, Bita. Have a great day.
You too.
Thank you, Bita. Have a great day.
For coming on. Bye.